Can a relative take custody instead of foster care in New Jersey?
In New Jersey, it is an often requested piece of relief from parents that the child go into custody of a third party as opposed to placement through the agency. Sometimes that can happen. Sometimes you'll have an aunt or a cousin go to court and apply for temporary custody of a child while a parent is getting themselves together or getting services from the state. However, the legal authority of the agency to compel you to engage in services or to seek a court order to compel you to engage in services so that the child can be safely returned to your care only kicks in when the agency files a court action. So for that reason, they're not typically going to want custody to go to a third party. They're going to want to have custody so that they can ensure that the child is safe, that the child has received some form of assistance regarding whatever the alleged child abuse or neglect is, and that the parent is required to do the things that are necessary to reunify the family. That doesn't mean, however, that your child can't be placed with your relative. So if your relative either is unsuccessful in filing an action in court before the agency files, or if the agency files and is granted custody, your relative can still have placement of your child. The legal authority of the child, the legal custody, goes to the agency, and the temporary physical custody of the child goes to the relative. The relative in that instance must comply with the agency's protocol in order to ensure that it has a safe home, a home that meets the legal standards that the agency has for placement of children, and in that instance there will typically be a court order that governs how much access you are allowed to have to your child, even though it might be your aunt or your sister or your best friend who has temporary custody of your child, because the legal custody is still with the state of New Jersey via the Division of Child Protection and Permanency.